Chapter 14. Motions to dismiss bills. 266. Office of a motion to dismiss. If there appear in the record some fatal irregularity in the bringing or prosecution of the suit, or if some fatal defect be manifest on the face of the bill, the Code provides that the bill may be dismissed on motion of the defendant because of such irregularity or defect. The object of the motion is to summarily end the suit, and, as a consequence, the ground of the motion must be both manifest and conclusive. If, by amendment, the irregularity can be remedied, or if the defect or omission can be supplied, it is the duty of the court to allow it to be done, for courts are instituted to enable complainants to have a hearing on the merits. If, however, it is manifest from the positive averments of the bill, or from other matters affirmatively appearing, that the defect is fatal and cannot be remedied, the bill will be dismissed. The statute provides this summary method by motion because, in such a case, the complainant having no standing in the court, the sooner the suit is ended the smaller the costs he will be obliged to pay. 267. Grounds of motions to dismiss. A bill may be dismissed on motion of the defendant. 1. For want of equity on its face. 2. Because unknown to the forms of the court. 3. If it appear on the face of the bill that the court has no jurisdiction of the person of the defendant. 4. For want of any of the prerequisites to the issuance of the writ. 5. For misjoinder or non-joinder of parties, where the fact appears on the face of the bill. 6. For multifariousness. 7. For such other grounds as may be specially declared sufficient by the Code. Some of these other grounds are 1. Champerty. 2. The omission of the allegation, in an insolvent estate bill, that the estate amounts to $1,000 in value, and 3. A failure to speed a cause according to a rule. All of these grounds will be more fully considered in the following sections. The first, 3d, 5th, and 6th causes of dismissal are in the nature of demurs or tenus, and may be raised by demurrer, but the demurrers for such causes must be special enough not to fall under the ban against general demurrers. A bill cannot be summarily dismissed on motion, except for the causes above enumerated. 268. Motion to dismiss for want of equity on the face of the bill. Whenever 1. The supposed rule of law or equity, on which the bill is founded manifestly does not exist, or 2. If existing, whenever the facts alleged manifestly fail to bring the case within such rule, or 3. If within the rule, whenever the facts alleged clearly show that the case falls within some manifest exception to the rule. In each of these 3 cases, there is a want of equity on the face of the bill, and a motion to dismiss the bill for that cause will be sustained. The court will not, however, sustain the motion, unless the cause thereof be not only good, but manifestly good, by which is meant that the court will not, on such a summary motion, search the bill for fatal defects, nor weigh in delicate balances any nice points of law urged against the bill. Such matters must be brought forward by demurrer. If there be any ground for reasonable debate as to whether there is a want of equity, the motion to dismiss will be overruled. Indeed, it may be said generally that the want of equity, to justify motion to dismiss on that ground, must be so manifest and so complete that the Chancellor would not be reversed if he should dismiss the bill on his own motion. If there be any equity at all on the face of the bill, even if it be defectively stated, the motion to dismiss cannot prevail, and, on such a motion, every reasonable presumption is to be made in favor of, rather than against, the bill. 269. Motion to dismiss because the form of the bill is unknown. While the Chancery Court looks to substance and not to form, yet form is necessary to substance. If the essential formalities of a bill were not adhered to, it would widen into such a loose indefiniteness of style and statement, and into such an utter abandonment of method and meaning, that it would be impossible oftentimes to define its substance amid the chaotic conglomeration of its multiform informalities. Pleadings must have some form, and no party has a right to institute his own form of a bill, for the form sanctioned by the court. In Chancery, no form is required not necessary to a clear, orderly, and respectful presentation of complainant's grounds of suit, and common politeness and good manners both require that this necessary and simple form be substantially adhered to. The dignity of the court, and the due, decent, orderly, and accurate administration of justice require that the ordinary form of a bill should not be substantially departed from. A bill will, therefore, be dismissed if it be unknown to the forms of the court. If a bill 1 should be addressed not to the Chancellor but to the clerk, or should have no address, or 2 if it should contain no prayer, or 3 if it should be in rhyme, or 4 if it should fail to name the party's defendant, or 5 if it should be in a foreign language, or so badly written as to be illegible, or 6 if it should be unintelligible, or 7 if it failed to give the names and residences of the parties. In any and all such cases, the bill would probably be deemed unknown to the forms of the court, and would be dismissed on motion. But if a bill contains allegations sufficient, if true, to entitle the complainant to some relief, the fact that the bill is inartificially drawn, or is misnamed by the draftsman, will not justify a motion to dismiss. In such a case, the court judges the bill not by its name or want of technical precision in its frame and averments, but by its substance and the matters of equity it sets forth. While the proper name of the bill will not atone for defects of substance, yet proper substance will atone for a defect in the name. The name of a bill is mere matter of form, and is absolutely immaterial, and, whatever be its name, the court will look at its allegations and prayers, and judge the bill thereby, and not by the particular name it may happen to bear. The rights of the parties will be determined exclusively by the matters of equity alleged, and not by the appellation given the bill by the complainant's solicitor. This is especially true of bills not strictly original, some of which have highly technical names, and others have various objects and offices. All such bills are judged by their averments and prayers for relief, and not by their names. What is meant by the maxim that equity regards the substance and not the forms of things is that if there be sufficient substance in the pleading, the court will not disregard that substance merely because of the want of some technical formality. 270. Motion to dismiss. For want of jurisdiction of the defendant. It has already been shown that the court will not entertain a bill when it has no jurisdiction of the person of the defendant, provided objection is properly made on that ground. This want of jurisdiction, when not apparent on the face of the hill, must be made to appear by plea in abatement. But when apparent, a motion to dismiss or a demurrer will lie to the bill. The local jurisdiction of the person of the defendant is a matter oftentimes of great importance to him, and when that jurisdiction is wanting, when the bill is not filed in the proper county, the defendant may object to the jurisdiction over him. This objection frequently appears on the face of the bill, because the code requires the county residence of the parties to be stated in the bill, and when the objection does so appear, the defendant may move that the bill as to him be dismissed. 271. Motion to dismiss for want of a prerequisite to the writ. Before a subpoena can issue or publication be made, the complainant must give the required cost bond or file the required pauper oath in lieu thereof. Such bond or oath is a prerequisite to the writ, and for the want of such a prerequisite the bill will be dismissed on motion. So, in an original attachment suit, a sworn bill containing a good ground for an attachment, and an attachment bond, or a pauper oath in lieu thereof are prerequisites to the issuance of the writ of attachment, and for the want of either of such prerequisites, a motion to dismiss the bill will lie. The motion to dismiss may, also, be made in a case of a fatal defect in any of said prerequisites. The defects in the form of attachment bonds and affidavits may, however, be amended, and where no attachment bond at all has been given, or one fatally defective, a sufficient bond may be given, even after a motion to dismiss for want of a sufficient bond. A bill filed on Sunday without the prerequisite affidavit may be dismissed on motion. 272. Motion to dismiss on other grounds. A bill may, also, be dismissed. 1 for misjoinder or non-joinder of parties, where the fact appears on the face of the bill. 2 for multifariousness. 3. For want of the allegation, in a bill to administer an insolvent estate, that the value of the estate equals $1,000. 4. For want of a prosecution bond, when the complainant's oath of poverty is shown to be untrue, or his cause of action frivolous or malicious, or is one that cannot be paupered. 5. For failure of complainant to comply with a rule to speed the cause. 6. For failure of a non-resident complainant to answer interrogatories by a given day on a peremptory order so to do. 7. For champerty or maintenance. 8. For uncleanness of complainant's hands. And 9. For want of jurisdiction over the subject matter of the suit. The last 6 grounds of dismissal may be relied on at any time before final decree. The other 3 grounds must be taken advantage of in due season, or they will be waived. A bill in Chancery cannot be ordinarily dismissed, on motion of the defendant, except for the causes enumerated in the statutes. This does not, however, prevent a bill being dismissed by the complainant himself, either orally, in open court, or in writing during vacation. 273. When a motion to dismiss must be made. The different modes of defense have been heretofore stated, and the order in which they must be relied on. It is too late to make a motion to dismiss because of some defect apparent on the face of the bill after demurrer, or plea in bar, or answer has been filed. The adoption of any one of these defenses is a waiver of the right to make a motion to dismiss. The only mode of defense that precedes a motion to dismiss is a plea in abatement, a defense which seeks to end the suit by reason of some objection outside of the merits of the controversy and outside of the body of the bill. All of the grounds of a motion to dismiss, except the one for want of equity, also seek to end the suit without contesting the merits. It is a rule of courts that, after a defendant has taken issue with the complainant on any of the merits of the controversy, he will not be allowed to set NP any defense that is based on some matter outside of the merits. A motion to dismiss, therefore, must be made before demurrer, plea in bar, or answer, or it will not be entertained, except in the cases hereinbefore referred to. 274. How a motion to dismiss may be defeated or avoided. There are 2 ways to meet motions to dismiss. First, to show that the motion is not sustainable on the face of the record, and, if sustainable, 2d, to avoid the motion by supplying the defect. If no leave to supply the defect be necessary, it should be supplied, if possible, before the motion to dismiss is argued. But if leave be necessary, such leave should be applied for before or during the argument of the motion to dismiss. The complainant may amend his bill or supply the prerequisites of the writ after a motion to dismiss has been made, and even after such a motion has been sustained. In the latter case, however, the amendment must be made, or the prerequisite of the writ supplied, during the term at which the motion to dismiss was sustained, or at least leave to amend or to supply must be obtained during such term, or within 30 days after the entry of dismissal. If the term is longer than 30 days, motion to dismiss bill allowed and dismissal set aside. John Doe vs. No. 618. Richard Rowe et al. In this cause, the defendants moved the court to dismiss the bill for want of a prosecution bond or pauper oath in lieu, and, it appearing that no bond or oath has been filed, said motion is allowed and the bill dismissed at complainant's cost, and an execution will issue accordingly. Thereupon, complainant tendered and filed a prosecution bond, and moved the court to set aside and vacate the order dismissing his bill, which motion is allowed, and said order of dismissal is vacated and annulled, and the cause reinstated on the docket to be proceeded in.